Thanks, Kelly. Good afternoon, everyone. As Kelly mentioned, we're here for the utility law review and update, and we're going to be talking about utility advocacy in the COVID-19 era. Again, I'm Ria Pereira. I'm a staff attorney from the Pennsylvania Utility Law Project. Also joining me is Brackbill, a staff attorney from the Pennsylvania Utility Law Project, and Josie Pickens, the co-director of the Energy Unit from Community Legal Services. So just to start us out, for those of you who are unfamiliar with our organizations, the Pennsylvania Utility Law Project represents the interest of low-income residential utility consumers across the state through policy and litigation. We also provide training, technical assistance, and support to legal aid and nonprofit community groups across Pennsylvania. And Josie, do you want to introduce CLS to everyone really quickly?
Sure. Hi, everyone. I hope your day is going well. Community Legal Services is based in Philadelphia. We provide free civil legal services to Philadelphians. The Energy Unit is a specialty practice that represents consumers in energy matters and advocates for affordable utility service.
Thanks, Josie. And PULP and CLS, we work collaboratively together. We focus on finding affordable solutions for utility service for customers and helping them access and maintain services across the state. So for today, we're going to start off by talking about our COVID-19 update. We're also going to give an update for everyone about the Universal Service Program design, as well as a short update about Chapter 56 rulemaking. That was a topic that we did address at last year's utility update. We're also going to talk about the new LIHEAP season, as well as other tools for addressing affordability for utility customers. And we're going to round out our discussion with talking about strategies for preventing termination and restoring service. So with that, I'm going to turn it over to Gio to start our COVID-19 update.
Hello, everyone. Good afternoon. Thank you for that introduction, Ria. So with the COVID-19 update, I'm going to start by describing the PUC emergency COVID-19 order. That is currently effective for the duration of the emergency proclamation, which was most recently renewed on until November 30th, 2020. And so currently the termination moratorium is tied to the governor's emergency order declaration, but it's unknown when it will ultimately be lifted. So we are looking to the PUC for further action. The PUC may vote to lift as early as September 17th, 2020. So the PUC emergency COVID-19 order, the moratorium applies only to regulated utilities. And in June, regulated utilities reported an approximately 800,000 customers were eligible for termination, and unregulated utilities it does not apply to unregulated utilities. So these would be municipal authorities, electric cooperatives, and they're not required to stop termination. And actually some of the unregulated utilities are starting the termination process. If you see that, please feel free to report it to us and let us know what you're seeing. With regard to utilities restoring service, they're encouraged to do so. However, they're not required to restore service. They were very much encouraged, but not required. So we can't guarantee that we can get a utility to restore service if you have a client who's been shut off, but we can try to contact and work with them if they were shut off prior to COVID-19 order. Next slide, please. The municipal water authorities. So these would be the Pennsylvania Municipal Authorities Association, PMAA, guidance to municipal water authorities. They were told to place a moratorium on terminations, restore service if previously terminated, to suspend and waive late fees, and institute payment assistance plans. The guidance is non-binding, however, and some authorities again began terminations this month. I was told that Dan and Dan Vitek and John will be presenting on this later in the plan conference if you want more details about municipal water authorities. Next slide. Evictions and foreclosures. On May 7th, 2020, the governor issued an executive order extending the moratorium on evictions and most foreclosures. This expired August 31st, 2020. Most recently, the CDC halted some evictions nationwide until December 30th, 2020, 31st, 2020. The latest news is that the governor has urged legislature to pass utility relief, including additional LIHEAP and water wastewater assistance. The Senate Bill 1307 and House Bill 2816 are currently on the table for $150 million in LIHEAP, the Low Income Heating Assistance Program, and water and wastewater assistance. Next slide. Okay, so this is about the PUC informal complaints. The Bureau of Consumer Services is still currently accepting cases from customers whose regulated utilities have been terminated, where the utility or supplier has first been contacted and refusing to restore service. So like I had said, it's only if the supplier has first been contacted. So the first step is contacting the utility and then going to the Bureau of Consumer Services, which you can expect a slower response from them. The BCS is also taking in cases that are safety related, which may be deemed an emergency situation or exigent circumstances. BCS is not taking unregulated utility off cases, but it's referring them to 211 Attorney General Bureau of Consumer Protection, Office of the Consumer Advocate, and referring small businesses cases to the Office of Small Business Advocate. BCS is investigating, mediating, and issuing decisions on the cases it takes in, and decisions are primarily being served electronically to the parties via email. There are some verbal decisions that are queued to be followed up by letter as soon as the U.S. mail service becomes available. All decisions are being electronically delivered to the utilities and/or suppliers. Again, please let us know right away if you're working with a client whose service is off and can't get through to the PUC to file an informal complaint. If you're advising a client who lost their job or just has a significant change in income, if they're not enrolled in CAP, we urge you to call CAP to apply for the Customer Assistance Program. This is typically calculated by the previous calendar month. And if the client's out of work, they'll be asked to submit a zero income form. If they don't have income, they must recertify more frequently, every 3 or 6 months. If the client is currently already enrolled in CAP, you should contact them immediately, and they can adjust their CAP amount based on the change in income. If they have a pending informal complaint, call regularly to check the status. At this time, I'm going to pass to my colleague Josie, my apologies, Josie Pickens, and she's going to discuss the universal service and energy burdens.
Hi everyone. So this slide here is an overview of the universal service programs in Pennsylvania, the suite of services and programs that are available to help low-income customers afford their energy bills. And all regulated gas and electric utilities are required to have these programs. You may be familiar with the names, but we're going to talk a little bit about each one in the context of termination prevention. There's the Customer Assistance Programs, or CAP. There's the Low-Income Usage Reduction Program, or LIHEAP. There's the Customer Assistance Referral and Evaluation Services, or CARES. And then there's the Hardship Fund. So I'm going to go to the next slide. And for people who have been keeping up with our statewide utility, affordability, advocacy, and our consumer protection work, I wanted just to give you an update on two things that were ongoing and that we have included in our updates in the past. So one has to do with the Commission's Universal Service Review and energy burdens. Now, energy burdens are the percentage of household income that the utilities are permitted to bill to cap customers. It's a range of possible energy burdens, but the goal is to get customers an affordable bill. And so the amount determined to be affordable was a subject of a recent proceeding. In 2018, the Commission initiated this comprehensive review of its universal service and energy conservation programs. Part of that review included looking at these energy burdens for cap customers to see what is an affordable burden. And we have been providing updates at plan conferences about our advocacy to get the Commission to lower the energy burden for cap customers. And we made a number of recommendations to improve universal service programs in Pennsylvania, and specifically advocated for a 6% energy burden. So on this next slide, you'll see that the Commission did revise its cap policy statement to substantially reduce energy burdens. And it was at the last plan conference that while we were presenting the session, we got news that the Commission had lowered the energy burdens. And it was a very historic moment because those reductions for customers from 0 to 50% of poverty, the new energy burden is going to be 6%, which is what we have advocated for. For those with 51 to 150 percentage of poverty, it'll be 10%. So that will be the target energy burden or percentage of household income for cap customers' electric and home heating bills. Now, prior to this change, those energy burdens could be as high as 17% of household income per month for customers on a cap program. So there are hundreds of thousands of customers who are enrolled in cap, and these numbers that are on the slide are the pre-COVID numbers. And when the Commission issued its order, there were nearly 2 million eligible cap participants. That number may rise in the coming months. So this change in the energy burden standard is a very big deal with the potential to benefit millions of consumers in Pennsylvania. The Commission's policy statement became effective on March 21st, 2020, when it was published in the Pennsylvania Bulletin. The last point on this slide, however, is a very notable point that we still have an advocacy campaign that is ongoing to get these new energy burdens adopted and implemented by the utilities. So although the Commission has revised this policy statement, these new burdens aren't yet in effect. In Philadelphia, we've had some good momentum, and the Philadelphia Gas Works is going to, by a pilot program, begin to incorporate the new energy burdens into its cap program starting at the end of this month. But in every other utility, we're still waiting on the adoption of the new energy burdens. So we hope to keep you posted with what we hope is good news as utilities begin to lower the capped energy burdens. And the next slide is just an update on the Chapter 56 rulemaking, which has concluded, and we gave an update last year about changes to the Commission's regulations to make it consistent with amendments to the Public Utility Code. As part of that rulemaking, there were 3 outstanding issues that were deferred to a working group. And those issues were: what form should a medical certificate take? recommendations to the PUC about guidance and interpretation of the protections for victims who are under domestic violence victims who are under a protection from abuse order or comparable court order, and privacy guidelines for consumers who consent to electronic notification of termination. So we participated in that working group. We're waiting on the Commission's guidance, but we are advocating for the pro-consumer interpretations of those issues. We want the medical certificates to be widely available. We want the form to be a variety of forms. We want to keep the Commission from requiring that the medical provider list his or her license number on the certificate. We are advocating to get these forms posted on utility websites. And for the protection from abuse order guidance, we're advocating for there to be standards and the maximum protections for individuals who need to obtain additional payment arrangement options because they are under those orders. So we don't have an update, but we want you to know this is an ongoing issue, and if you see clients who have issues with any of these med-certs, PFAs, electronic notification of termination, that we would be interested in those stories.
Thanks, Josie. I think next in line is a discussion about the Low-Income Home Energy Assistance Program, often called LIHEAP. Now, the next LIHEAP program season is going to run from November 1st, 2020 through April 9th, 2021. Now, the caveat to that is that grant recipients from the prior year may receive a postcard or application as early as October, so be on the lookout for that if people are wondering about the new season. It is possible to apply for LIHEAP assistance either through local county assistance offices or online through the Compass portal. For those of you who don't know, I did provide a website there. There is an advantage of applying through the Compass portal in the sense that households can get a preliminary eligibility determination if they do apply online. And for consumers who are worried about not having a computer, the site is mobile friendly. So they have announced the new grant amounts for the 2020-2021 program year. First, we're going to talk about the cash grant amount. The minimum is going to be set at $200. The maximum is going to be set at $1,000. This is going to be the same as the last year. There has been a little bit of a change to the crisis grant amount. The crisis grant minimum is going to be set at $25, and the crisis grant maximum is going to be set at $800, which is an increase of, I believe, about $200 from the previous maximum in the last year. There's a few different eligibility criteria for both the cash grant as well as the crisis grant, and we're going to go into that on the next few slides. But just initially, keep in mind that when you're talking about cash grant amounts, it's going to be based on a number of factors, including household income, location, as well as the type of heat that the household does have. In terms of crisis grant, we always kind of put the asterisks and remind people that a crisis grant must be sufficient to resolve the crisis. Now, that can either be the crisis grant taken alone or in combination with other sources of financial assistance, such as hardship funds, other grants that might be available. So let's initially start talking about the eligibility criteria for cash grants. First, household income must be at or below 150% FPL. Now, this can be measured either as the month before or 12 months before the application, whichever benefits the consumer, the customer. And this is an advocacy tip that if there are customers that might be on that line, it might help to do that math, and it might be a place for additional advocacy as well. The next eligibility criteria for the cash grants is home heating responsibility. And this means that the applicant is responsible for the main source of heat. And normally utility companies just communicate directly with county assistance offices to verify heating responsibility. However, things get a little more tricky in the case of tenants. Sometimes it often does require a landlord verification or a lease that shows responsibility for the main source of heat to rent. And if tenants do qualify for a cash grant, they're going to only qualify for 50% of that cash grant, which is another big caveat as well. So when we talk about showing home heating responsibility, I also wanted to mention that it could be shown in two essential ways. It can be shown through a utility bill for the utility that's essentially responsible for heat in the individual's house, and that it comes in the name of the applicant. But again, as I mentioned, it can also be shown potentially indirectly through payments to the landlord through rent. And again, this might require a lease term or a landlord verification to be shown. The other thing to keep in mind is that a heating source can come in a variety of forms. It can not only be gas or electric, it can also be wood, oil, propane. And, depending on where throughout Pennsylvania you're advocating, it could vary largely. And one more caveat on this slide is that we often talk, when we talk about LIHEAP cash grants, of primary heating source and secondary heating source. For customers, applicants who do have a secondary heating source that they might be seeking a grant for, it is possible, but it's normally required that that secondary heating source, essentially if the primary heating source requires it to function. And the example of this is electric service, if it's necessary to run a gas furnace, is the traditional example that we do use for this.
Ria, I'm sorry. If I could just interrupt here. This is Kelly.
Yeah, absolutely.
Thank you. For all the attorneys on the webinar right now, I've just launched a pop-up question box. If you could please respond, just hit yes or no. It'll disappear from your screen then. I need this in order to show that you're participating for CLE credit, and you must answer both poll questions. One will be later on. You'll have 2 minutes to do this, and Ria, please feel free to continue. Thanks.
Okay, thank you, Kelly.
Mhm.
So the next eligibility criteria for the cash grant that we're going to want to talk about is residency. And this requires that household members are permanently residents in Pennsylvania. There is interesting kind of exception to this is in the case of recreational vehicles such as campers or RVs who might actually qualify under this criteria, but they are required to be in a licensed facility year-round. There's another kind of exception to this that is sometimes overlooked, and this is in the case of victims of domestic violence. It's sometimes called the battered woman exception, and this is regardless of citizenship, so it does provide an exception to this. For people who are interested more about this, you can look at the LIHEAP state plan. It lists a number of kind of documents that might be required to show this, including collateral contracts with school counselors, health professionals, social services agencies, police, courts, affidavits from the person, or eyewitness accounts. I'm sorry, there we go. So let's talk briefly about the eligibility criteria for the crisis grant. Now, the first three we've kind of discussed in regards to the eligibility criteria for cash grants. Again, you have to show that household income showing that there is a home heating responsibility and the residency requirement. But in addition, for crisis grants, there also needs to be an actual or imminent home heating emergency. And this is essentially the crisis component of the crisis grant. And this can be shown through a variety of ways: termination notice, or 15 days of fuel or less. And this can be through oil, propane, wood, coal. And like I previously mentioned, the crisis grant must resolve the crisis generally within 48 hours. The utility may potentially accept less than what was originally stated to the customer as owed to resolve the crisis. And this is a great place for advocacy where, finding out some of the numbers and seeing what can be negotiated with the utility does come into play. So a special topic that we get a lot of questions normally on that we wanted to kind of address a little more head on during this presentation was the intersection of immigration and LIHEAP. Now, certain lawfully admitted non-citizens are still eligible for LIHEAP regardless of when they entered the U.S. Now, of course, the other LIHEAP eligibility criteria that we have been talking about, they still need to show, but the helpful part is that the public charge rule does not apply to the LIHEAP. So when you're looking at the actual list of qualifying non-citizens, they include LPRs, asylees and refugees, Cuban and Haitian entrants, as well as non-citizens who have been battered or subject to extreme cruelty in the U.S., and this is normally shown by a specific visa designation. For those of you who are looking for more information about the full list of statuses and acceptable documentation, Appendix B of the LIHEAP state plan is going to be the best source for that information. And the other kind of interplaying rule that might entail some immigration overlap is that if there is an ineligible adult in the household, an eligible child can still apply for LIHEAP. Now, the one caveat and warning to this is that the adult's income will count for purposes of determining eligibility. But when you're looking at the actual number counts, so the individual will not count for the household size determination, which might make it harder to, depending on the household, obviously, to meet that income qualification, but it is still an option, which is helpful. So some overlooked LIHEAP issues that we want to draw attention to, some of which we've already talked about. First, tenant eligibility for household heat is included in rent. We've already discussed that there might need to be a landlord showing a verification, or there might need to be some kind of lease term. We've already talked about ineligible parents with eligible children. If people in their advocacy are noticing that there are bills in the name of third parties, please do let us know if people are having issues connecting to LIHEAP access. It's something that we are watching out for. The other kind of overlooked LIHEAP issue that often comes up when you have people who are moving or transitory populations is that LIHEAP can pay late fees or reconnection fees, but it cannot pay security deposits for customers who are looking to establish or connect to service. Also for customers who are looking to connect to service, if LIHEAP cash grant is used to connect to service at a new residence and the household has a prior past due balance, the LIHEAP cash grant may only be used for up to 50% of that prior balance as well. So helpful to know depending on the particular circumstance of the consumer that you are helping. And I know we've been talking a lot about LIHEAP during these slides, but LIHEAP is one of a tool box of potentially a few different assistance means or mechanisms that can kind of overlap and come into play when helping customers with arrears or stay connected to service. So first, and sometimes the most obvious, is utility-run assistance programs. And this, again, is obviously utility-specific, and often, especially with the bigger regulated utilities, will include bill payment assistance, potentially hardship grants, as well as usage reduction and energy efficiency assistance to help get some of those bill amounts down. As well, there are certain prohibitions about charging security deposits for CAP eligible customers. Those are the low income customers at or below 150% the FPL. So in terms of vulnerable populations, there are a number of protections available for victims of domestic violence who have either protection from abuse orders or other court orders with evidence of domestic violence. Now, there's a specific slide that's going to address this later in the presentation, but I do just want to say at the outset that with victims of domestic violence who might have PFAs or other court orders, some of the protections do include things like protection from termination for non-payment from essentially the name of another person other than the customer. Generally, you cannot charge victims arrears accrued in someone else's name, even if they lived at the residence when their arrears were accrued. As we'll talk about later, there are more flexible payment arrangements that are available for qualifying victims, as well as certain other notice protections and provisions that are in place in terms of that what's sometimes called that last knock rule, the personal contact requirement that's immediately preceding termination. And you will talk about this more as well, but for that requirement, if there's no personal contact, which is generally a across the board requirement, the notice for victims is posted at the property and termination is then delayed 48 hours. So it's kind of an extension of that provision as well. We've talked about federal assistance through LIHEAP as well. And, I know COVID has brought up the possibility of additional assistance potentials coming down the pike as well. And then there are additional water and telephone programs available for unregulated water service. We'll talk a little bit later, I guess, in the convention and plan conference about this. There's a whole session that's been scheduled on unregulated water that one of our other attorneys is involved in, if anyone is interested in that. And keep in mind, when we're talking about tools for addressing affordability, utilities often do offer payment arrangements. The terms and how these payment arrangements are going to be structured are going to be highly utility specific. And again, this is an area of kind of knowledge and advocacy for specific utilities to see what payment arrangements customers who might qualify for. And we have listed here as a last resort, referring for bankruptcy. Now, we obviously don't like to do that. It's a last resort for a reason, but if all else fails and, the overall analysis and recommendation is for bankruptcy, it is an option for some of this debt. So I think I'm going to turn it over to one of my other presenters to carry on with terminations.
Hi again, everyone. This is Josie. Before I get into the substance of the slides, want to remind everyone that most of these options to avoid termination apply to the regulated utilities. So I'm not going to, there are a couple of slides that touch on the unregulated utilities, but for the most part, this is for the regulated utilities. And then I just want to, because we're in a little bit of a holding pattern, we're hopeful that the commission will continue the moratorium on shutoffs consistent with the governor's proclamation, but we don't yet know what the commission will do and whether terminations will be allowed to resume in the short term. We know that at some point, though, they will resume and the commission's order will be lifted. And we want you to have these tools available to you. But I want to put a disclaimer out there that people should not be getting shut off regulated utilities for non-payment at this time. So we're going to shift into the termination slides. We always talk about authorized terminations, and I think one of the reasons we include this slide is that there sometimes our clients' service may be shut off because a landlord has constructively tried to constructively evict and shut off the service. And one way to determine whether that has happened is to talk to the client a little bit about whether they've been issued a termination notice or whether any of these standards or authorized terminations apply. So the utility can terminate for non-payment of undisputed delinquent account, or failure to comply with a payment arrangement, for the failure to complete a security deposit, or for the failure to permit access to utility equipment. Terminations may only occur Monday through Thursdays, not on Fridays or weekends or holidays or the day before a holiday. So if a client says that their service was shut off on a Saturday and it wasn't, there was no indication of an emergency, that would have required the utility to do that. You may want to start asking questions about what other causes of the termination, and whether there's any situation with the landlord, because we've been seeing a lot of those cases. There is a termination exception, and throughout the slides, we mention where victims or survivors of domestic violence who have the PFA or other court order are protected, and where the service was provided to someone else. It was provided in another person's name. The service may not be terminated to the holder of the PFA for non-payment. The next slide talks about the requirements for notice from the utility. The utility has to provide a written notice at least 10 days before termination, and the notice is effective for up to 60 days. And this timing may become important for us if the commission lifts the shut-off moratorium, because we don't know whether the 10 days will coincide with the start of LIHEAP season or the start of the winter protection on shutoffs. So we definitely want to pay attention to the dates on the notice and whether or not something beneficial is coming down the road in the next 10 days, like grant assistance or additional protections from shutoff. After the written notice, the utility has to attempt what's called personal contact, but they have to attempt the contact, and they can do that either in person, by phone, or electronically. The electronically piece may be concerning to some people, but do know that the customer has to affirmatively consent to receiving electronic notification. So the utility is not permitted to just send a text message to every customer. Only those customers who've consented to receiving electronic notification will have the personal contact attempted in that way. And often the consent for that notification happens at the time that the customer signs up for utility service. There is an additional protection, some additional consumer protections for those customers with the protection from abuse order or comparable court order evidencing domestic violence. For those customers, the attempted personal contact must occur immediately before the termination. And if the utility is unable to make personal contact, the utility has to post a notice outside the property and delay the termination for 48 hours. So at the top of the session, we talked about the universal service programs that are available for low-income customers. And these programs, people often confuse them with one another, or they confuse them with payment arrangements, or they think that customers can only get one form of assistance, and that is not the case. So these programs work in concert with one another, and customers may be able to utilize more than one. The CAP programs are pretty, I hope they're pretty familiar, but they are customer assistance programs that are, the utilities are required to operate all of the regulated gas and electric companies. Some regulated water companies offer limited assistance programs. The benefits of CAP are lower monthly payments, reduced rates on the monthly bill. The past debt or arrears on the account at the time of enrollment are frozen. And the customer may be eligible for arrearage forgiveness that is earned over time. And there are rules, different rules at each utility about the forgiveness and whether it's the first time you enroll. But the general benefits of CAP, one of them is arrearage forgiveness. To be eligible for CAP, the household income, and that's the gross income, has to be at or below 150% of the poverty line. The customer has to be payment troubled, and that means different things at each utility. For some, the customer has to be behind on the bill. For others, the customer simply has to meet the other eligibility requirements. The customer has to have their income periodically reviewed, so they do have to recertify to remain enrolled in the CAP program. A practice pointer, although the utility may ask for the Social Security number on the CAP application, the Social Security number is not required. So there may be advocacy there if that you're able to do if the customer is denied because they either don't have or don't want to provide their Social Security number. The next type of universal service program is hardship funds. These are cash grants, typically up to $500 to resolve a utility crisis, payable directly to the utility. The terms can vary by utility, but typically the eligibility is 200% of poverty or below. It's important to see what the eligibility guideline is in your service territory, because a person may not be eligible for CAP, but they may be eligible for the hardship program because the income eligibility may be higher than that for CAP. They may require recent payments or attempts to make payment on the account, and the utility may waive those requirements. And they require a temporary hardship and the ability for the hardship fund to resolve the crisis at hand. Some utilities do prohibit CAP customers from receiving hardship fund assistance, but will make exceptions. The CARES program is a little known and little used program that utility advocates have helped to shape and improve through our policy advocacy over the years. But this is a program for customers who are having trouble paying their bills, have short-term problems that are leading them to be unable to pay. The CARES workers at the utility may be able to refer those customers to social services agencies, offer budget counseling, and most importantly, they can sometimes help customers enter into special arrangements, special payment arrangements. So this is as an advocacy tip, the CARES division of the utility is a good place to go to try to negotiate a payment arrangement for your client, because the utility has wide discretion to resolve the customer issue. The client may not be able to get any assistance or help from the utility commission, but they may be able to negotiate with the utility to get the utility to exercise that discretion. And then the low-income usage reduction program, these are the utility weatherization and conservation programs that are operated by the utility. And the benefits include an energy audit and energy conservation measures. And these can range from things like energy efficient lighting to appliance swaps and sometimes more substantial conservation measures. The programs are different at each utility. Some of them will notify the customer, and other programs the customer can call to ask for an energy audit. So you have to check the requirements at your local utility. The income guidelines are typically at or below 150 or 200% of the poverty line. For tenants, the tenant does need the landlord to approve the conservation measures. Important note that CAP customers may be and are often required to participate in LIHEAP, but during COVID, many of the utilities have suspended the LIHEAP requirement or are not performing LIHEAP services because of the social distancing requirements. So if you have someone, people should not be getting removed from CAP right now for failure to obtain a LIHEAP audit, but at some point that will be permissible again. And then payment arrangements, which are different from the programs that I just mentioned. Although our clients often conflate payment arrangements and CAP, and they can get tricky because a customer could have had both a payment arrangement and a CAP and be enrolled in CAP. But a payment arrangement is an agreement where the customer, if they admit liability for the service, the billed service, they're permitted to structure that debt to amortize it or pay it over one or more payments. So the key words there are that they admit liability. So if you have a client who does not believe they are responsible for the debt, they should not enter into a payment arrangement. If they're unable to afford the arrangement, they should not enter into it, especially if they have other options available to prevent a termination. There's a difference between arrangements that are issued by the utility and arrangements that are issued by the state's Public Utility Commission. The utility has discretion to offer as many payment arrangements as they want and for any length of time. So again, it's always worth attempting to negotiate an arrangement, even if a client has had arrangements in the past. But for the PUC, the state utility code does put limitations on the types of arrangements that the PUC is able to offer. And as a general rule for customers where the service is on, including customers who are within 30 days of having been shut off, the income in the house is at or below 150% of the federal poverty level, the commission can authorize a payment arrangement of up to 5 years, 60-month payback time frame. The PUC, though, cannot require a utility to enter into a second arrangement absent extraordinary circumstances. So a lot of times when you hear customers, clients, or even advocates say you only get one payment arrangement, they're simplifying this commission, this public utility code language that says the commission can't require the utility to give a second arrangement unless there's this change in circumstances. For customers who have service off and are seeking to restore, the commission will require the payment of a reconnection fee. And for customers who are at or below 150, the maximum arrangement is only 24 months. So they're not very long arrangements for customers who have significant debt, but they may be an option to help some customers either prevent or service or restore service that's been shut off. There are some exceptions to the payment arrangement standards at the commission. One important one is, again, for the victims of domestic violence who are under that protection from abuse order or comparable court order. They may get more than one commission arrangement. They may get multiple arrangements from the utility, and the utility is going to factor in the size of the balance, the ability to pay, the payment history, the length of time over which the bill accumulated. For customers who are on CAP and who have CAP arrears, they're not eligible for a payment arrangement from the PUC. And what that means is a lot of times if a client was on CAP and they get a shut-up notice and they contact the commission will say, well, we don't have the authority to issue a payment arrangement for you because you were on CAP. And you may have encountered that in the past, but that's because the commission does have a limit on its ability and is unable to issue arrangements on CAP, where there are CAP arrears. There is a slight exception to that, but it's most often the case that customers have significant CAP arrears and are not able to get arrangements from the commission. For the payment arrangement assessment, please remember that the customer may owe less to reinstate a CAP arrangement or to reinstate a payment arrangement than they owe in full on the balance. And so the notice, the shut-up notice may list the full amount of the arrears, but the customer may be required to pay a much smaller amount to reinstate the most recent arrangement. And so when you're contacting utility, please remember to ask for the amount needed to reinstate the customer in CAP or the most recent payment arrangement. And when the customer is put back on CAP, the CAP benefits should begin to receive the rest of the CAP benefits, including the frozen arrears and the arrearage forgiveness.
Josie, excuse me, if I could just interrupt. This is Kelly. I need to launch the second of the CLE question polls. So if you are an attorney and would like to request CLE credit for your participation in this session, please respond to the question now. You'll have 2 minutes to do that. And thanks, Josie. Feel free to continue.
Thank you.
Mm-hmm.
So I have 2 more slides in my part of the presentation, and they have to do with tenant protections. And this is a frequent area of advocacy and something to be on the lookout for as if evictions move forward. So there are protections for tenants when the landlord is responsible for payment of the bill, but the landlord doesn't pay. And there's state laws. The USTRA, which is the Utility Service Tenants' Rights Act, applies to unregulated utilities. But USTRA has become a familiar name to advocates who both in the energy advocacy world and in the legal services world, people know about USTRA, but that specific law applies to the unregulated utilities. And then for the regulated utilities is the Discontinuance of Services to Lease Premises Act, which is in the Public Utility Code. And they both provide the tenant with important protections so that they're able to preserve service or to restore service if the landlord fails to pay the bill. The utility has to notify the tenant of the arrears. They have to provide the tenant with an opportunity to pay the last 30-day bill. They have to allow the tenant to pay the utility bills going forward, and the tenant does not have to put the bill in their name. The tenant has a right to deduct that utility payment from their rent, and the law protects the tenants from retaliation by the landlord. So if the landlord seeks to evict the tenant because the tenant was able to preserve the service and is deducting the bill from the rent, the law actually protects that tenant from retaliation. In addition, a landlord does not have the authority to contact a utility and voluntarily shut off service to a premises that's occupied by a tenant. So a landlord is not able to just call up the energy company and say, shut off service to unit B. The tenant has a right to notice and the ability to keep the service on consistent with those state laws. So that is another area where you want to evaluate whether a landlord is misbehaving. And you may be able to contact the utility. If the utility didn't provide the notices to the tenant, you may be able to get the service restored and get those notices issued to the tenant. And then the next slide covers foreign load. And this applies, you may have clients who report to you that they believe they're paying the bill for another person's usage or for a common area of an apartment building or house. So under the state law, the tenant, if the tenant's meter is sharing or is covering service to common areas, and those areas are not individually metered, the landlord is responsible for the full bill for that residence until the landlord resolves the foreign load and individually meters those areas. And so if a tenant, usually it's a tenant situation, if a tenant suspects that they are sharing the load for another tenant or for a common area, they should ask the utility to do a foreign load investigation. And if there's foreign load, the utility is required to put the bill in the landlord's name. And the tenant is only responsible for the bills going forward after the foreign load is resolved and the landlord or owner of the property corrects the foreign load and individually meters those areas. And the foreign load concept and protection applies only to regulated utilities.
Thanks, Josie. I'm going to cover some special issues related to termination. First, we're going to just briefly talk again about protections available for victims of domestic violence. As I previously mentioned, there is a qualifying protection where victims of domestic violence with PFAs or other court orders that have that evidence of domestic violence, the utilities cannot charge or terminate based on arrears accrued in someone else's name, even if they lived at the residence when the arrears were accrued. There are also flexible payment arrangements based on individual facts and circumstances. What these are going to look like in practicality are going to vary somewhat by utility, and again, finding out what individual utilities are doing, and advocacy does come into play there as well. And the one warning caveat for victims with safety concerns is that in order to access these protections, they must provide a copy of the PFA or whatever that qualifying court order that does have evidence of domestic violence would be to the utility. Some additional advocacy that can be done in this area is finding out what the individual utilities' best practices are for protecting those information, and finding out if there's any special record retention requirements for those documents as well. We're also going to talk a little bit about medical certs, sometimes called med certs, and there's some interplay with COVID, as I'll mention in a second, but in general, a household may obtain a medical certificate to stop a termination if a household member has a serious illness or a medical condition which requires utility service to treat their illness. Examples of this include asthma, if it requires air conditioning in the summer, or diabetes where it requires refrigeration for medication. Now, with these medical certificates, a medical professional rather than the utility will get to decide if it is a qualifying condition. And again, figuring out if the consumer does have a primary care physician is the first step in that process. Now, with medical certificates, the rule is that a medical certificate stops termination for up to 30 days from the date of issuance. So again, there is an interplay with the termination moratorium that is in place as a result of COVID. Right now, it might mean some strategic thinking about how you and the customer does want to use these medical certificates, because as we'll see, there is a potential that that these medical certificates are limited. So a customer may submit a new certificate every 30 days if he or she pays all current charges by the due date. The customer then may renew the medical certificates 2 times, so that's 90 days of protection, even if they do not pay the current charges by the due date. So it really is dependent on those current charges, how many times that renewal might occur. And a last special topic we want to cover related to termination is the winter moratorium, just reminding everyone the dates for these. Again, the winter moratorium is low-income households are protected from termination in the winter, and that's going to run from December 1st to March 31st. And it's going to apply to households who are at or below 250% the FPL. And this is going to apply to gas, electric, and heat-related water service. And sometimes the definition of heat-related water service does get a little tricky, but one example of it is radiator heating systems which require water. And the asterisk caveat on this slide is that a winter moratorium is a moratorium on terminations. It does not guarantee restoration of service if it is already off. Now, with the conjunction of LIHEAP, it's again an area for some advocacy and checking with the utility exactly what terms restoration can be given on to individual customers. So now I'm going to turn it over to Gio, I believe, who's going to go through some information about the dispute process with utilities.
Yes, I'm next. So with disputes, if you remember earlier, Josie had talked about how authorized termination is non-payment of an undisputed delinquent account. So I'm going to be talking to you about disputes and disputing a utility bill. Step 1, initiate a dispute with the utility. So the utilities have the obligation to address disputes, and the clients have the obligation to give the utility a chance to resolve the dispute before going to the Public Utility Commission. The tip number 1 is that utilities have a broad discretion to resolve customer disputes. So the magic words you want to say are, I am disputing blank, whether it be, X amount on the bill, or if there's a foreign load, you got to tell them I'm disputing this. And then you request a utility report or an account report. And the client must continue to pay any undisputed bills. So after step 1, we bring it to the PUC complaint. And an informal complaint, you're going to the PUC Bureau of Consumer Services. You can call that number, 1-800-692-7380. And filing the informal complaint will temporarily stop termination if it's filed before the day of termination. And then a formal complaint gets you an administrative hearing before the administrative law judge, and any appeal of a formal complaint is going to go to the Commonwealth Court. You must be a licensed attorney to represent a client before the PUC, but advocates and paralegals are definitely able to refer a client to file pro se, and they're definitely able to provide information about a client's rights. And then next slide is filing an informal PUC complaint. Again, you call the number 800-692-7380. Timeliness, so there's a 3-year statute of limitations on whatever you're disputing. And then remember that for the informal complaint to stop termination, it has to be filed before the day of termination. So you don't want to wait until you get the notice and then it's the day of or the day after they're coming. So you want to do this right away. And then practical tips, just stay engaged in the process. Follow up on your complaint if you haven't heard anything, get to know who your investigator is, and provide all relevant information and copies of any documents you think are relevant to your dispute. The third and final step will be filing a formal complaint. You follow the appeal instructions on informal complaint decision, 20 days notice of appeal, 30 days formal complaint. And there's a form that is provided at that website there. And you can use the discovery process to build your case and negotiate a settlement with the utility company. Next slide. Okay, negotiation is required before filing a complaint. Utilities have significant discretion. Remember that when you're talking to them, that they can do things, and you just have to be persistent. And start by asking utility to review the account, be direct with what exactly you're requesting and disputing, and ask for a stay of termination to review case. It's best to develop a relationship when you're negotiating with the utilities and disputing a utility bill. The next slide I have for you, some referrals. First, there's us, PULP, the Pennsylvania Utility Law Project, pulp@plegally.net. Our number is 717-236-9486. There's community legal services. You can find them at clsvilla.org, the Office of Consumer Advocate, and the PUC Bureau of Consumer Services, which is what I was just talking about with filing the informal and formal complaints. We have a PULP LIHEAP Advocates Manual coming next month. The LIHEAP state plan you can find at that URL, the Universal Service Contact Numbers, and Universal Service Plans, which contains the ability program rules for utility-run affordability programs. I think the next part is just, answering the questions that we have in the chat. Let me see if I can find them. Yes, we have.
And I think Kelly might, sorry, this is Ria. I think Kelly might have been monitoring them, unless I'm stating something incorrectly, Kelly.
Nope, you got it right. First question from earlier in the session says, what does, quote, encourage mean, unquote? Is there any benefit for companies to restore service?
Okay, so when they release, the emergency order from the PUC, they obviously prohibited terminating service during the time of the order, but then the final sentence of that said, finally, we encourage utilities to restore service to customers whose service has been terminated to the extent they can do so safely. Encourage just means that, the PUC supports them restoring service. But as far as, please correct me if I'm wrong, Ria, but there's not a benefit for the companies who do choose to restore the service other than that they're complying with what is recommended.
Well, I'd just like to add to that, Gio, and Josie can obviously add as well, that, I think the benefit of restoring service is one, there's, a public interest benefit, obviously, which comes along with, looking like you're doing what's in the public interest. But there's also a benefit that you're restoring potential for payable customers as well. So we've seen that dependent on the utility, of course, utilities, some of them have put in place certain, at least action plans for allowing or trying to mobilize restoration efforts. And, it's definitely an ongoing process. Is there anything you want to add to that, Josie?
I think the question, the quotes around encourage kind of calls out that language we would have preferred it to have been a directive, and we have used it in our advocacy on behalf of individual customers to try to move the needle with some of the utilities and to leverage some discretionary payment arrangements and in advocacy to kind of improve LIHEAP policies and that sort of thing. But the language it would have preferred to have been a mandate.
Okay. The next question we have is, who administers the hardship fund programs? The utilities themselves?
Yes, and in coordination with local community-based organizations, and utilities often partner with these organizations to offer matching energy assistance funds, so that if the community organization, every dollar that the community organization is able to provide to the customers matched by the utility.
That's all the questions that we have.
If anyone has any additional questions, we are obviously here if they think of anything last minute.
I'm not seeing anything pop up.
All right. And while I have everyone on the line still, I will say I know there's a lot of information in the slides and a lot of links to things. If anyone is interested in getting more information or copies of anything, feel free to reach out to any of us.
I think the last slide has our contact information. Perfect.
Okay, well, thank you, Ria, Gio, and Josie for being here with us today and presenting all this helpful information to everybody. And have a great afternoon, everyone.
Thank you, Kelly.
Thanks, everyone. Thank you, Kelly.
We have some people in the chat looking for a copy of the PowerPoint.
And Kelly, I'll leave it to your discretion. You're the master of ceremonies, how you want us to distribute that, if there's an easier way.
You should have received an email from me on how to upload any materials you have in the Sketch conference app.
Okay, I will figure that out. If I have any issues, I will let you know.
Absolutely. Reach out to me and let me know if you didn't get the email or anything like that. So we're just kind of trying to combine all the handouts and materials in the conference app, and people can download them from there.
Awesome. Thank you.
Okay. Thanks. Take care, everybody.
Have a good day. Bye.
You too. Bye-bye.